I am a vice president of the Russian Chamber of Commerce and Industry, Chubarov Vadim. Today online we'll be attending Mr. Zygin, acting chairman of the International Commercial Arbitration Court, and Mr. Patsov Artyom, director of legal service, dom.rf. Also will be attending Mr. Machiev Shamaral, chairman of the International Court of Arbitration at Kyrgyz Republic, and Mr. Umar Oseni, Secretary General of the Arbitration Center of the Organization of Islamic Cooperation. He will join us at 2 p.m. Also, Mr. Abubakar Inomov. He will also attend us later. And at the end of the session, we are planning to sign 2 documents. It will be signed between the ICAC and the International Commercial and Arbitration and the Chamber of Commerce of Republic of Tajikistan. We are ready to start. I would like to start from the topic of today's session. So, we are ready to start. ICAC as an effective dispute resolution mechanism under the sanctions regime. I'm representing the Chamber of Commerce and Industry. So what are the sanctions? Mr. Vladimir Putin, the president of our country, said that we publicly publish these sanctions, over 15,000, and you can freely open them and revise all of them on all of the languages they're published. So on the slide you can see with the red sign where you can find them. And on this slide you can check the detailed information where to find them. They are published. What countries has give us the sanctions, the UK, the USA, and other countries too. At the same moment, our Chamber of Commerce is also evidencing some force measures, circumstances in foreign trade transactions. So when the parties have signed the contract and they're ready to follow the contract's but there are sanctions and they cannot to follow the contract, but they are ready to follow them. But they cannot do this because of sanctions. So here is a statistics. We follow this situation and we give them the certificate of force majeure. And you can see that year by year the number of these certificates is growing. And the least number was in 2019. And of course we agreed to this application, received them, and confirmed the force majeure circumstances. And you may notice that right now the number is going over thousands. Please check the statistics of 2023, last year. So the companies had already understand what are the sanctions. So they, so we receive the applications according to these sanctions. And we can see that year by year the number of these applications is growing and not decreasing. but we are happy that a lot of foreign countries signing the contracts with our countries. And we are ready to move to the arbitration. We have more than 90 years of history, and we have adopted the law of international commercial arbitration. This is the highest law of our country, and we are working according to this law with the annexes 1 and 2 to the law of the Russian Federation. So we described what is the international activity, and we have the same document on the maritime activities. I would like to say that in 2015 we have a lot of claims on arbitration, and we have made a lot of decisions. To be honest, right and wrong ones. That time we had more than 2,000 claims, and so the government decided to make a reform on this situation. And at that time we understood that we need to make some changes. Of course, 25 countries agreed to the international arbitration, to the courts, but they didn't understand the basic things of the theme. So we have adopted a new law in 2015. This is a law on arbitration in the Russian Federation, and the consequences of this adoption is that we are able to solve the disputes between foreign companies and domestic companies, and we have more than 26 branches all around the Russian Federation in the subjects of the Russian Federation. And all of the branches are working together with the Chamber of Commerce and Industry of the Russian Federation. The branches representatives are attending this meeting, so if you have any questions, you can contact them. And I would like to say that the court that is working under the Chamber of Commerce and Industry is following all the laws of the Russian Federation. What about the benefits of disputes and arbitration? So, this is the main methods to solve the disputes between parties. This is international arbitration and not the domestic arbitration. The Russian Federation is a member of the most famous convention. More than 170 countries are signed the New York Convention in 1958. And the decisions that are being made between two parties can be made in 169 countries. So you just need to go to that country to apply some documents and register them, and after that you can have the decision on your dispute. So ICAC is the main method tool to solve disputes between parties. This convention is working since has been working since 1958, and USSR has joined this convention too, and a lot of countries has joined them later. This makes the arbitration much easier and convenient. Today we have arbiters from 25 countries. We have renewed this list because the world is changing, the politics is changing, and we are thankful to our colleagues, to these 25 countries, to work with us. And if you have any questions, problems, disputes with arbiters from these countries, you can contact them and choose this certain arbiter. And we are open for new arbiters from other countries too to join us. For example, arbiters from Kazakhstan has joined us recently. Chinese arbitration body also joined us, and we will sign new documents with the Guangzhou Association. This is the second association in China. So we are making a good job. Of course, the arbitration is not so strict as a domestic courts, but we provide the confidentiality to our clients, and only Secretary General know about the disputes. And you can trust me that the Secretary General can honestly serve to you and protect your confidentiality, your privacy. What about other benefits? Lately, the politics in the world has changed, so we need to we need to change our methods, but we still continue to work on that. So here I'm think that about 80% of the ICAC words are recognized and allowed for enforcement abroad. And we are making the decisions fairly, and it is understandable to all the countries that are getting these documents. And moreover, the mechanism is very convenient and good working. This is not only on the paper, but in real life too. And it is the indicator that there are a lot of countries that our decisions were recognized. You can see the list of the countries on the slide.
So, as an example, just recently in 2023, the Court of Appeal in Brescia, Italy, has approved and enforced our decision. So what did they say, actually? First of all, they accepted and acknowledged our decision on their territory. The second point, the court, in its comparison, just mentioned that it is practically the only method in resolving international disputes. So when they actually announced the acknowledgement and fulfillment of our decision in Italy, that was actually another witness. So, New York Convention, this is what we take and accept. So we bring these decisions to those territories which are located abroad. And actually, this is a chart showing how our arbitrage is popular. You heard about certain events, London arbitrage and Stockholm arbitration court. So these were several cases that were considered in our courts and in these international courts. And even there, we compete with these leading centers of international arbitration courts. So we are becoming more and more reliable, more and more trustful, and these are countries that address to us for resolving different international matters. Before China became second country after Russia, so it goes China, Belarus, Germany, and Turkey. So the vector of the economic development, the policy of the state has been changing, and this statistics shows what countries and what companies actually addressing to our arbitration courts. And what about the figures and amounts of disputes? I mean, in terms of finances, what is the statistics here? I would like to tell you a little bit more about our council. On Islamic laws. It is Islamic legislation of spiritual council of Muslims of the Republic of Tatarstan. So Islamic banking is available in 4 republics of the Russian Federation: Tatarstan, Dagestan, Chechnya, and Bashkiria, Bashkortostan. So more than 20 companies are listed in this roster of central bank as a pilot project we actually are promoting. We work closely with Rustam Nurgaliyev, and we have agreed that we are going to engage those contracts that has been already signed, including some clauses stipulating the solving of disputes in international commercial arbitration courts, including Tatarstan branch, where they can use the rules of Sharia for resolving Muslim disputes that are happening on these territories. Thank you so much for your attention, and I would give the floor to our further speakers. Professor Ivan Zikin, acting chairman of the International Commercial Arbitration Court at the CCI of the Russian Federation. Dear friends, colleagues, I'm glad to have this opportunity to speak in front of such an authoritative audience, and I would like to support the idea articulated by our previous speaker. Currently, as we are speaking of the international commercial contracts, we have a real choice whether we go to a state court or commercial arbitration, and the sides are preferring to go to commercial arbitration courts because there's a New York Convention, international legislation and agreements that actually are adopted all across the globe. And when we discuss these issues, we have to realize that this is the choice, the most appropriate choice for our businesses, what actually they are to decide what arbitration institution do they address to, and they have to have enough information. One of our purposes of this meeting is to offer such an information And my topic of this speech is international cooperation of the ICAC, International Commercial Arbitration Court, in contemporary conditions at the present stage. So first of all, about the forms of this cooperation, and I will share certain examples. What are the addressees of this sort of cooperation? This is arbitration institutions of friendly countries, and we are mostly looking at cooperation with friendly countries. First of all, this is mutual information about the activities, exchange of experience to improve work, introduce modern practices in the dispute resolution processes. So here I would like to mention that, of course, it is very important to have personal, direct contacts, which enables the actors to reach the best results. Of course, we heard that when Vadim mentioned that we have the number of arbitrators from 15 countries. This is, from 25 countries, and this is good evidence of this situation that even under sanction limitations, they are participating actively to resolve international disputes and do it willingly. Next. I believe that our meeting confirms time and time again about the importance of personal contacts to sustain efficient collaboration. And one of the forms of such collaboration is making agreements about the cooperation in the field of international commercial arbitration that is signed by foreign CCIs and leading arbitration centers in the world. There are more than 20 agreements like that are acting. One more is that we are ready to sign within the framework of this particular forum. I would like to draw your attention to the importance of such an institution that is advisory body It is a consultative institution of the international commercial arbitrations of CIS in terms of our commercial arbitration. It's a long title, but in a nutshell, the leaders of certain arbitration institutions across the territory of post-Soviet space meet on a regular basis between each other and discuss the results of their joint work, further prospects, and the main goal of such a work, actually there are goals that are listed on this slide: the development and popularization of international commercial arbitration across the territory of CIS, forming international arbitration practice, and improvement of the activity of arbitration centers under the CCIs in CIS countries. Next slide shows us the geography where these advisory body committees meetings actually take place in Chisinau, Chisinau, St. Petersburg, Yerevan, Tashkent, Dushanbe. Three times we had these meetings in Moscow, even this year, and I would like to underline and emphasize the importance of such a forum and its actually importance for conducting our further effective work. One more track is participation of our organization in various international forums, conferences on the topics of international commercial arbitration. And once again, a few examples to this. Far Eastern Economic Forum, the year of 2022. We discussed the arbitration issues. We have signed a memorandum between ICAC and Guangzhou Arbitration Commission. Far Eastern Economic Forum of 2023, we also discussed issues on international commercial arbitration, and we signed, just a moment, a number of agreements between Maritime Arbitration Commission and CCI, Chamber of the Russian Federation, and China Maritime Arbitration Commission. Probably you have noticed that this forum is of more wide economic character, and Far Eastern Economic Forum in the framework of these wide topics, it is unavoidable to leave out, we cannot leave out the serious issues of the legal framework, effective solution of different disputes, and arbitration is a great tool for this. I would like to draw your attention also to our Kyrgyz conference. It was the event dedicated to 20th anniversary of the International Arbitration Court and CCI of Kyrgyz Republic. Due to the organizers, we have had a fruitful exchange of opinions on relevant issues, and of course we have listened a lot of interesting reports. It was really an interesting event. And in 2023 in Kyrgyzstan we had a conference on digital law, relevant issues of the digital legal issues. Next, Caspian Economic Forum. We have discussed the advantages of ICAS and Caspian states participated, like Kazakhstan, Russia, Kazakhstan, Uzbekistan, Iran, Turkmenistan. So those countries that are greatly referred to the Islamic world. 2023, Mongolia, we had a very interesting joint trade and economic forum where we have touched upon pretty interesting spectrum of economical and other problems. We met with arbitration community of Mongolia, China, Russia, and discussed a lot of relevant and interesting questions. Tehran 2023, in the framework of business mission, was the Russian-Iranian Business Forum. that was held as part of the business mission, and we've signed memorandum of understanding between the ICAC at the Arab Chamber of Commerce and Industry and the Arbitration Center of the Iranian Chamber of Commerce. And what is peculiarity of this organization? There is an organization in the framework of the United Nations. It is so-called UN Central Working Group. It exists since 1966, and one of these groups is dedicated to arbitration, and ICAC actively involved in this group's activity. It is definitely a very useful event. And another point, so international cooperation. The Chamber of Commerce and Industry of the Russian Federation organized the International Student Competition in International Commercial Arbitration, named after Mikhail Rosenberg. Not only leading higher educational establishment students participated from Moscow, St. Petersburg, Vladivostok, Chechnya, but also there were students invited from Kazakhstan, Tajikistan, Uzbekistan, Belarus, Kyrgyzstan, China, Vietnam. So the students are competing in real time, working on relevant disputes, so it is really close to a real situation in business. What is interesting about it is that, for example, Kazakh colleagues were winners of one of those sections. Chinese section actually won over one of the Chinese universities. What does it mean to us? Young people really learn quite quickly about the commercial arbitration. Completing my report, I would state that international commercial arbitration is a dynamic sphere, and this dynamic character should be accompanied with the development of the activity of arbitration institutions, and international community should work a crucial role in this process. What should we recommend in this collaboration? Having, for example, quick arbitration, dispute consideration, conducting preliminary arbitration, accelerated arbitration, using modern technologies based, the technologies based on international acts, and first of all the Convention on International Sales and Trade as of 1980, and we have to use it really. Thank you, Ivan. Thank you so much. We give the floor to International Arbitration Chairman of the International Arbitration Court at the Chamber of Commerce of Kyrgyz Republic, Shamar Maychiev.
Good day, dear Shamaral. We are so glad to see you today. You have 15 minutes. Let's get started. First of all, I would like to say that I'm really grateful to the organizers of today's summit. This is a very important forum. We have attended it last year offline, and we were really grateful for the networking. We have signed the contract, the memorandum of cooperation, but today I would like to talk about our court. Our court was formed September 26, 2002. We have a long experience, rich experience. We have reviewed a lot of disputes, provided with dispute resolutions. We are working under the constitution of our country. We have joined the UN Convention on the recognizing the international arbitration resolutions. We have joined the Vienna Convention, and we have joined the Vienna Convention in 1862, and we are working as making the list of our arbiters. We are forming the small jury, and sometimes we let the arbiters that are not in the list but also can join our court and make some decisions. So we had that example last year. We had a dynamic arbitration. From the beginning, there was no trust from the parties, but we have offered them to work on the small reglement, and we have offered them one of the arbiters from the list and one out of the list. And the second party accepted one arbiter from the list and one out of the list, so we made the 4 members group to solve the problem. We have spent 3 months to resolve this dispute, and the decision was made due to these 2 arbiters out of the list of our arbitration court. If you can see the slides, the next slide is about statistics. You can see the history of our arbitration court, the history of our court starting from 2004. And we are making about 80 to 100 resolutions every year. So we have made more than 100 courts with international members. If you present these statistics in the chart on the map, you can see how many decisions we have made. This is an interactive presentation. You can open the link. We have 42 regions in our country, and there are different parties that claim the issues to our court. And if you open the link, you can see the geography of our work. And on the next slide, you can see the whole world, the map of our international partners where we have been working. We need to add Jordan and Litva to this map from the last year. We have added 23 countries to our international cooperation. The most active countries are the Russian Federation, Kazakhstan, Tajikistan. We have the biggest number of disputes with them because we are neighbors, and a lot of companies are working. Right now, we have 9 companies from the UK, and in the UK we have also revised the papers. So the next slide is about cooperation with arbitration institutions from other countries. Of course, we are working with our neighbors, with the Turkey. One of the closest friends is People's Republic of China. We have signed the memorandum with the Shenzhen Arbitration Court and with the universities in China. And in 2017, we have signed the agreement on cooperation, and we have made the list of 50 arbiters from our countries. We have proceeded in our cooperation. We have opened in Kyrgyz Republic the third-party arbitration court of Asia, former Bishkek Commercial Court. Right now, the members of this court are our court, Guangzhou University, Shenzhen Arbitration Court, and some bodies from China. We have already revised more than 40 disputes with Chinese companies. We are continuing our work. We have already signed cooperation documents with 5 more China courts from Harbin, Shanghai, and some other cities. We need to provide the accreditation, need to open the branch of our court in Shanghai. It is the branch of third-party arbitration court in the Shanghai city. We have stopped this work during the pandemic of coronavirus, but we will continue to work on that. As for Islamic finances, and in 2006, we have signed the regulation on the implementation of Islamic financing principles, and we have changed the legislation so that companies could provide services on Islamic finances according to the Islamic legislation. And we have added new chapter to the civil code with a chapter financing in accordance with Islamic financing principles. And in 2021, we were approved to further develop Islamic financing. Right now, we have no barriers to work on this theme. We have added some more arbiters that are working on Sharia law, according to Sharia law. So maybe this time in the nearest future, we could work on this rule. I hope so. So the next slide, please. So what about taxes and disputes concerning the taxes? In January 2022, we have made some changes to the tax code in Kyrgyzstan. So we let the parties to find out the best solution for them if they are working in foreign markets too. And we have let them to change the taxes, get the tax refund, and so on. In 2022, we have adopted the tax code, but in 2023, we have made some changes so that we have added that in the nearest 5 years, according to the willing of the taxpayer, the government court or the third-party arbitration court could adopt the dispute applications. But unfortunately, we had some misunderstandings between the Russian Federation Council and Kyrgyz Republic Council, so we need to unify them, and we are going to revise them. Every year, we have published the books on the arbitration, commercial arbitration. Right now we have published more than 67 books of 67 authors in 15 countries. So, to be short, we have more than 300 foreign arbiters, have 64 domestic arbiters, and 138 arbiters on the local branches. We have revised more than 1,000 deals from 12 countries. This is the result of our work that I wanted to share with you today. Thank you so much. Thank you so much, dear Shamaral. We are waiting for you on next year, and we would like to see you in person. Thank you so much to join us today online. And of course, we are continue to cooperate with you. And I would like to give the floor to the Director of Legal Service of Dom.rf, Mr. Patsev Artyom. The topic is a combination of Russian law and Sharia restraints as applicable law in commercial arbitration. Good day to everyone, dear colleagues. I would like to talk not only about abstract cooperation, but I would like to talk about more concrete things. How can we cooperate? How can we use the Sharia laws in our work? Is it even possible to use the Sharia laws during the... So, first of all, I would like to say that we have some applicable laws, and before preparing for this session, I was asking my colleagues and a lot of professional lawyers from Russia or from other countries. They were surprised because they have never heard about Sharia laws. What is it? What is it, Sharia? How does it work? Of course, it's just a lack of knowledge. So I would like to briefly describe how can we use the Sharia requirements, how can we use the Sharia law in our practice. First of all, applicable law can be separated to two types. First one is a procedural, and the second one is substantive laws. So the substantive rules are a legislation of the country where the arbitration is located, subsidiary regulations in addition to the regulations that we are using in the International Commercial Arbitration Court. And, of course, as a substantive rule, we are using the legislation of the Russian Federation, of course. As for substantive laws, so how can we describe the law? How can we describe the matter of fact? So this is due to the parties. They can choose the decision. They can make the decision by themselves. Maybe choose the third-party regulation, or choose the non-governmental body to resolve their problem. And the parties are free to choose wherever they would like to stick. Lately, more often, the parties that are taking part in the court in the Islamic countries are choosing as a applicable law Sharia laws. Why don't I say Sharia rights or regulation? Why it is Sharia? So what can we say about Sharia? This is a Muslim vision of the world, of the current situation. But if we think from the historical place, this is the pace traced by the God. But this is not only about religion. This is more about legislation, about turnover of the companies. But actually, they have a lot of in common. And during the development of Muslim civilization, this religion restraints, religion regulation has become a part of social life, and we need to stick to them. We need to follow them. We need to follow these beliefs, these restraints of religion. And Islamic lawyers expanded and developed. It was expanded and developed by fiqh, the human understanding or interpretation of the divine Islamic law. That was.
So this human understanding or non-violence, like norms that are formalized, because there were many different schools, Muslim legal schools, and this track has been developing pretty rapidly. But unfortunately, this development was stopped by Mongolian invaders in 12th century, when Baghdad was destroyed with many libraries and wealth of wisdom accumulated for centuries. And this legal thought was completely stopped. And this concept was actually occupying the central place in the world systems, Islamic in particular. And this vacuum was actually filled with other religions and other systems related to housekeeping and international trade, European rules and European laws, as a matter of fact. But actually, the Sharia norms was, of course, mostly related to personal status of people, family law, and actually criminal law. And so many people have such an understanding that it's kind of demonizing approach in some sense. So in the 20th century, closer to its other half, second half, for on the way to confirmation of this status that would regulate business relations. It didn't happen all at once, but first of all, from the very beginning, the convention, Vienna Convention of 1980, about obligation agreements, actually it could be taken as a basis for international commercial arbitration, and the British court took it as the basis for acknowledgement of competencies and applicability of Sharia norms to applying it in disputes between the company from two Muslim countries, and it can be actually taken into consideration in accordance with British law. So formally, these norms of Sharia was actually taken into consideration in accordance with British law anyway. So this logic is quite defective, let's say, and many of you know that Mexico Victoria is like a list of international trade principles that are not approved and acknowledged, but they were used and have been used. But in 2008, there were some changes made to Vienna Convention, and since that time, the obstacles for utilization of Sharia norms, implementing them in part of the law, were actually revoked, and so the practice since then acknowledged the possibility of inclusion number of clauses, in a number of clauses. So norms of Sharia have gone a long way until the acknowledgement, the moment of acknowledgement, them is the way to be utilized in courts, and in particular arbitration clauses. So first of all, they can be actually referred to in terms of national legislation if they refer or include Sharia norms like in legislation of Saudi Arabia, Sudan, and so on. And secondly, norms of Sharia can be referred to on the basis of certain parts of contract relations, like, for example, interest rate prohibition, or in terms of status of the parties. And there are other relations that are coming out of these agreements that can be based on certain national rules, national legal systems. But there should be a clause that would stipulate that this norm is not contradicting some sacred or divine rules or principles related to Sharia. And this is a principle actually used in Roman law, like the justice principle, and many arbitration institutions, international courts pretty often say that they have a prohibition of application of any national right, any national law, so they are based merely on justice concept. But if subsidiary will not have enough justification or arguments that they can apply on the basis of Sharia principles, of course they can refer to national legislation that they choose. So what actually is hindering for this application of the to applying these principles? Of course, codification of these principles and norms of Sharia. We have to clearly understand how arbitrators should behave when they actually are dealing with disputes, how they should accept certain norms, formalize them on the basis of legal schools, legal systems. Because even in Islamic countries, there are various interpretations of Sharia principles, so we can't say that they have a certain formalized and unified system. The third problem is a low number of arbitrators sufficiently qualified to apply Sharia in commercial disputes. And I would like to conclude my report. Let's actually come back to what we began with. I believe that we can actually adopt Russian law to the norms of Sharia, and because divine revelations and prohibitions on the basis of which the Islamic legislation exists. Actually, we already made some changes in the Russian legislation in certain constituents of the Russian Federation, and of course we preserve the existing legislation, but partnership financing is not yet well developed enough, so this central bank is working on this issue closely. About 12 to 15 organizations are involved, and more than 80% of these organizations are from Tatarstan. And those obstacles they still have in application and applying of the Sharia principles, prohibitions. Of course, we can try to solve these matters through, for example, extending the time of consideration of certain disputes, considering this clause on the basis of ICAC branch in Russia, I mean Russian ICAC branch in Tatarstan, because this is one of the leading organizations of this pilot project. And secondly, as Vadim Chubarov mentioned, that they had come to an agreement with Spiritual Council Muslims of Tatarstan that they would help them in terms of interpretation and obtaining knowledge of this sort by arbitrators, and it would fit norms of Sharia. Of course, these norms are quite successfully implemented in a number of states, like Malaysia, for example. They have a consultative council under the Central Bank of Malaysia. They implement this practice pretty effectively. So I think this will help our pilot projects in general in terms of arbitration as a method of resolving disputes. Thank you. Thank you very much. I will come back to this, Artyom. Of course, before we met the Secretary General of Mr. Hazratov Rustamovich Nurgaliyev, we actually had some points to discuss, and we need to think how should we converge this. And I would like to give the floor to Secretary General of the Arbitration Center of the Organization of Islamic Cooperation, Omar Hosseini. And is he connected, actually, my question, to our technical stuff?
15 minutes for your report, and say us please about your center. Thank you.
Thank you very much, Your Excellency. It's a pleasure to be with you all today, and I would like to begin by apologizing for not being there in person today. And it's really important to be part of this distinguished panel where we discuss very important issues relating to the international commercial arbitration. First and foremost, I would like to start from the last presenter, where we had a discussion relating to the relevance of Sharia law in Islamic arbitration in general. Sorry, I don't know whether you can see my presentation. Okay, I'm trying to.
Unfortunately not.
Sure.
Not with.
Okay, I'm just gonna reshare. Okay. I'm having some technical issues here.
Now we see the first film of your presentation, sir.
Окей, теперь
just for not being there in person today. Let me start from where the last speaker stopped. Even though the topic of my presentation is the OIC Arbitration Center, resolving disputes and bridging nations. Now, this topic is very important because the OIC, the Organization of Islamic Cooperation, with 57 member countries, have come together through the Islamic Chamber of Commerce to establish this body known as the OIC Arbitration Center. So when you look at this presentation with what was discussed earlier in terms of the relevance of Sharia in international commercial arbitration, we'll see that it's important to closely look at the relevance of Sharia. Now, I say Sharia, I do not say Sharia law here because, you know, when I interpret Sharia, in English, I say Islamic law. So generally, we prefer to just say Sharia. Now, I would like to move on to the next slide to kind of give you an outline of what we'll be seeing today. So let me go to the next slide quickly. Now, the OIC Arbitration Center was established, by the different countries in the OIC region, and it is based in Istanbul. It's pretty new, basically. It's a new body, but it was really spearheaded by the Islamic Chamber of Commerce and Development with collaboration with other countries. And we try to provide a neutral, effective, and a party autonomy-driven platform for parties to resolve their disputes. Again, just like any other international arbitral body, you do have the different facilities we have for virtual hearing. And one thing that is unique is the International Supervisory Board, which has 21 highly qualified experts who are arbitrators. And if you look at the role they play, they supervise the proceedings from appointment of arbitrators up to the arbitral award itself. And you will see the reason why this body is unique. Because when it comes to international arbitration, now I say international arbitration because the scope of this arbitral center is both investment arbitration and commercial arbitration. So it actually has both. So the center was established specifically to focus on disputes emanating from bilateral investment treaties and agreements between different countries, apart from the component of commercial arbitration. So it's important to lay this foundation. So this is one of the very few arbitration centers established with a treaty. So it's good to kind of give that foundation to the discussion. And we are hosted by the Turkish government here in Istanbul, and this is where the headquarters is. Now, moving on to the next slide, I would like to kind of tell you the timeline of the establishment of this center. Now, we have different decisions made at very high level kind of meetings at the OIC level. We have the COMSEC, which is the Economic and Commercial Corporation of the OIC. And as a matter of fact, the need for this center for the 57 OIC countries was actually discussed at the Council of Foreign Ministers of all the OIC countries. So that led to the kind of decision of COMSEC, and later you have this, you have what they call the Home Country Agreement between the Turkish government and the Islamic Chamber of Commerce. So this is actually the connection you have when it comes to the establishment of this body. And ultimately, you have what they call the Statute of the Center, as well as the Host Country Agreement. So we are here as an international organization in Istanbul. So I'd like to just move to the next slide, which gives you a glimpse of the objectives of the center. And of course, I've mentioned investment disputes and commercial disputes. Of course, we're also looking into mediation. We have the arbitration rules in place already. We are currently working on the mediation rules. And we also focus on one unique aspect called Islamic finance arbitration. This is unique to the global Islamic finance industry. And as someone who has played a significant role in the Islamic finance industry through my writings and consultancies, so I'm sure it's kind of timely for us to come off to develop the capabilities of the center in Islamic finance arbitration. And I would like to say that the principles of Islamic contract law are not so different from the civil law or even the Russian law. You only have a few differences here and there. So if parties stipulate that they are going to use Islamic law or Sharia as the governing law of a particular contract, which is subject to arbitral proceedings, I don't think that is really an issue. So I agree with all the previous speakers on this. But again, it's difficult to find experts who are arbitrators and also experts in Islamic law. There are few of them globally. Now, when it comes to specialized arbitration like Islamic finance arbitration, there are very few experts also. That's why at the moment I'm thinking of coming up with.
И поэтому мы решили выпустить книгу по исламским финансам и арбитражу. Поэтому таким образом мы бы хотели создать таковую возможность в этой сфере, чтобы позволить обсуждать и развивать в дальнейшем.
The governing law of arbitration. So I guess this center established in Istanbul is uniquely placed to help resolve investment disputes, commercial disputes, as well as Islamic finance related disputes. So we welcome the Russian Federation and the whole Islamic world to use the platform to resolve this dispute. Now, before I leave, the one other part I'd like to emphasize on is the ability of the center to leverage on its thought leadership to kind of provide reforms on dispute resolution and dispute management for OIC countries and beyond. Now, let me just quickly move to the next slide. Now, the next slide actually gives you...
Excuse me, sir. We had limit of timing. So you have 2 minutes. 2 minutes, please.
Sure.
Finalize,
okay, thank you,
please.
Mr. Chairman. So let me move to just go to the next slides as well. Okay, this is just the organizational structure of the body. So you have the board of trustees, the board of directors, And of course, the International Supervisory Board, which I mentioned earlier, where you have highly qualified experts sitting to actually supervise and oversee all the proceedings. And of course, you have the Board Executive Committee, the Rules Committee, and the Secretariat General, which I lead. Now, the next slide to conclude, just give you, the photos of those who sit on our board. The next slide, it's the International Supervisory Board. Okay, this is the Board of Directors. There you have, and you have the International Supervisory Board in the next slide. So, just to conclude, what we have is a diverse composition of supervisory experts that are uniquely placed to actually provide a truly good global platform for dispute settlement in investment and commercial disputes. So we welcome the collaboration with the Russian Federation as well as the entire world to use this unique platform, which is relatively new, to resolve your disputes. I thank you very much for your time and for inviting me to speak here today. Thank you.
Thank you very much.
Thank you. Thank you so much.
Arbitration, of course. Уважаемые коллеги,
Dear colleagues, I would like to give the floor to the Director of the Tashkent International Arbitration Center at the Chamber of Commerce and Industry of the Republic of Uzbekistan, Ms. Diana Bayzakova. Thank you so much, dear colleagues, for the opportunity to be today here. I would like to say big thank you to organizing committee of Kazan Summit for the paying attention to all the details during the preparation to this forum. I'd like to say that I'm often attending these type of events, and I'm deeply proud of us. Can you hear me? Can you see me? Yes, we can see you and hear you. Very good. This year in March, our Tashkent International Arbitration Center, we have organized the conference on the arbitrage questions, and we have concluded that arbitrage has overcome all the difficulties, and it will continue to be a key tool in dispute resolution. And after these several months, I can strongly believe that arbitration is a preferential method in the dispute settlement in the international field. I would like to present you my presentation, my PPT. Just a second. Can you see my presentation? Yes, we can see, waiting for your comments. So going back to the topics, we understand how important the reforms in the Uzbekistan are, and in the CCI of the Uzbekistan, we have established the Tashkent International Arbitration Center, TIAC, and in Paris, we have launched our body. And maybe you already know that the first attempts to make some changes in the field were started in the early 2000s. Before establishing TIAC, we had two obstacles. The first one is that the parties of different countries couldn't choose the international arbiters to settle the dispute. And the second one is that there were no chance to use the foreign laws to resolve their problems. Today we don't have these obstacles, and the parties can have some benefits in TIAC. In 2021, we have adopted new law on international arbitration, and we have become a member of international body that is working in accordance with international laws. We are one of the youngest arbitration courts in the world. I will show you the statistics later. And the GAR has pointed out that we have the best innovation by an individual or organization, and we have and we can resolve all of the conflict situations. So that means that our regulations, our laws, cannot allow some affiliated person to become an arbitrator in the court. This considers the secretary and the people who are responsible for making a decision in TIAC. This March, we got some great news from, and we have been awarded as a best innovative company in 2023. We have been surprised, but one of our team joked that this is a PR that was free for us. According to the latest statistics, we have registered 12 dispute resolutions, and 9 out of 12 resolutions had the Russian footprint, had the Russian parties. So I advise you to use TIAC as a neutral form in the dispute resolution. So you can you have to pay less than 30% on arbitration expenses. And for example, if you have a claim on $1 billion US, but you can save more than 42,000 US, but on this table you can see that even though our fees are quite higher than of the others, most talented arbiters, but in the conclusion, at the end, you will pay less. What are the other benefits of asking TIAC for help? We have a so-named Russian desk. Our secretaries, all the members of secretary fluently speak Russian, and you can pay in rubles too. The payment option in ruble is one of the key benefits. And full support users of the secretary. We are doing our best to reply to all the claims as fast as possible. I have already mentioned our experts, our arbiters, but I would like to highlight it once again. The parties that are seeking the resolution from our center. So they can also can have the experts in the council, but our fees are much cheaper. And on the latest session of the inner body that is making the decision, we have made some decisions on managing of sanctions, and we have made some decisions on how to choose the arbiters. We will publish this guidance on different platforms. And when we choose the expert, when we choose the arbiters, we consider all the obstacles, we consider all the neutral experts from Russian Federation as well. And on this slide, you can see the latest statistics. We got almost 60 claims from all over the world. And the first claim concerning the third-party government was registered in the June of 2023. In 2020, we have registered for the first time the claim, and the parties of this claim were from Russia and Singapore. So who is making the procedural decisions? This is not the Chamber of Commerce in Uzbekistan. This is not our government. We have 5 members of Arbitration Court. You can see them on the slide. Maybe you know some of them. For example, Joe Lee, former General Secretary General in Hong Kong, Emilia Onema, she's a member of Arbitration Court, TIAC. And I would like to remind you that we don't have so much time. In 2023, we have signed an agreement with Jus Mundi. So we are publishing non-confidential information, and we are protecting the privacy and confidentiality of our parties. And you can see the example of that on the slide. In conclusion, I would like to give an example of the project, the most successful case. After that case, we were awarded with a GAR award. And in 2023, TIC and HKIC, we have signed the cross-continental agreement where we described the responsibilities. So this is a unique case. We have formed a unique regulations on this topic. This is cross-institutional collaboration, and this is good example of our work, and we have already received a lot of requests for using this regulation, and you can find more information on our website. I would like to end my presentation about how do we make the international dispute resolutions. I often highlight the topic in the framework of international summits. In the Kazakhstan, we had no cases when we got cancelled because of the disagreement between our legislation. And We have made the decision with Russian Arbitration Center against of the petrochemical company in Russia. This is also one of our most successful cases.
Проигравшей стороной была госкорпорация. Это не помешало Верховному суду вынести решение об исполнении. Коллеги, благодарю еще раз за ваше внимание. Я буду только рада дальнейшей связи, контактам. И если у вас есть какие-то вопросы, конечно, буду рада на них ответить.
Спасибо вам большое. Спасибо. Я предоставляю слово Абу-Бакру Бабахоновичу Иному. Я уже представлял его, говорил о том, что он в 2021-2024 годах был председателем Международного коммерческого арбитража при ТПП Республики Таджикистан, а сейчас он координатор немецкого проекта. Абу-Бакр Бабахонович, вопрос имплементации искусственного интеллекта в арбитражном производстве, очень тема интересная, но не более 12 минут мы должны с вами еще соглашение подписать. Пожалуйста. Мы вас видим, пока не слышим.
Sorry, I am speaking to the wrong channel. Thank you so much. We can see and hear you very well. Thank you. Dear colleagues, it's a great honor to have the floor on such a remarkable event. And considering the fact that I have a short time slot, I'll try to be as fast as possible. As far as artificial intelligence concerns, I actually already articulated my position during the council meeting. Actually, AI is making great successes in our modern technologies, and our goal is to reduce the load and help and assist participants of the arbitration process to let them work efficiently. And we would also recommend to use it for dealing with statistic data in such matters as ground and soil operations, working with clients and transferring these disputes. And this technology is very similar to the technology of legal forecasting, and it can analyze millions of court decisions and offers the information that may be relevant for proper decisions. So this possibility of estimation, such systems are available in the world. Corporate dispute solutions so many issues can be resolved in automatic mode. So, for example, it can help to resolve important court decisions on the basis of those that happened in the past. And we are in charge of resolving about 60 million disputes per year. There are many sites like that, and a lot of various events dedicated to this topic. There are tools for artificial intelligence implementation. And of course, I believe that arbitration tools and institutions of our countries that are related to this topic have to start training the artificial intelligence systems on the basis of their data basis. And I see interesting prospects for online arbitration on the basis of these technologies that help a human to make a correct decision, to enable them to make a proper solution and minimize the time frame in which they can do this task. And to be in good control of their data and make sure they are secure. Artificial intelligence is not to be ignored. Of course, it's not wise trying to ignore it, and lawyers should use artificial intelligence for the purposes of legal practice and adopt it and transform it in a proper way. We all use machine learning when modeling various structures. Actually, when we visit a website, they ask us if we are a machine or a human, and we have to make some steps to confirm that we are human. Unfortunately, we don't have time for deeper talk on this topic, and I think that all of these technologies can influence the key stakeholders and participants of our arbitration market, and those who implement artificial intelligence and digital tools, it can save a lot of time and effort. Especially it is relevant for the at the beginning stage. Sometimes the whole team spends a lot of time to make some preliminary data put together. So we also are able to avoid the negative consequences of human factor like tiredness and some other issues. So people are using internet platforms, and it allows to save time. This is a remarkably interesting possibility. It expands the arbitration opportunities, and arbitrators are using artificial intelligence. But we have to consider that sometimes these technologies may be expensive, and on the basis of the existing legislation, we have to also keep in mind that in certain cases only human legal expert can be involved at certain stages, and the variety of forms of following the legal structures and frameworks of different countries like United States, Great Britain. They have what do they have as a source of their legal system? Of course, not all of us can afford certain things, But in the framework of specialized convention and memorandums and agreements, and on the basis of these legal frameworks, there is a special organization created, so we need a unified consultative body that would be analyzing the enforcement practices and would lead our arbitration legislation to new levels. So my proposal is that how can we actually implement the advanced experience and best practices, how to implement those nuances that relate to Islamic banking, for example, and except for everything our colleagues mentioned, we have few centuries experience using Islamic banking, Islamic spiritual. There was Qazi, a spiritual court, who resolved disputes in ancient times, and we could take this experience and somehow implement it into our legislation. Abu Bakr, thank you, and this is a positive note, and let us conclude your address. Thank you so much for having me, for giving me this opportunity to speak for such a important audience. And I would like to thank organizers and Shamaral, who brought great contribution to Uzbekistan system of arbitrage, and I actually used a lot of his works in my work. So unfortunately my term as a chairman is completed, and this is my colleague who will be taking over the position of the chairman. So I would like to introduce him and wish him success in his future activity. And we believe that our arbitration will move higher and reach your level, your arbitration level. Yes, okay. Abu Bakr, do you have the text of the agreement? Yes, thank you so much. Now we will ask Mr. Zikin take his seat where the text is available. And the audience on the right from me and on the left from you, I would like to ask you to move to this side, please, because our cameramen are requested to avoid this space, to arrange better visibility for filming. Yeah, please relocate if possible to this side. Thank you. So we get to signing the agreement between the international CCI of the Russian Federation in the face of Mr. Ivan Zikin and International Commercial Arbitration of the Chamber of Commerce and Industry of the Republic Tajikistan, Nikmurod Nurov. Please let us sign this agreement online, considering the speeches of your representatives. This is a regular procedure. Ivan, are you ready to sign? Yeah, Nikmurod has already signed, as I saw. Okay, let us exchange the signed agreement. It comes to force according to the regulations of CCI. Let's congratulate our arbitration center with this event and wish success all of us and our Tajik comrades in the development of international arbitration in the framework of bilateral relations, and I wish all of you success. Kyrgyzstan, Tajikistan, Uzbekistan, International Islamic Center, and it will let us be closer to each other. And we conclude our session. You were going to make some announcement, right? Unfortunately, it is not heard in the booth. This announcement is not available to international audience. Thank you so much. Thank you, our speakers, and everyone participated in this session. Have a great day.
Сейчас все фотографироваться.
Let's make a group photo, please.